know what people are going to be thinking. So let's just say you got a date of July something. So at the end of June, you filed the papers you're talking about with the courthouse or the clerk to establish that it's a court of record, and then there's no response. If there's no response and you had a date set, doesn't that imply that no one's acknowledged the jurisdiction and that you still have to show up for your date, or am I getting that wrong?
I should split up between two. I'm talking about civil, and let's say you get a parking ticket or whatever ticket. When I've gotten parking tickets, and with the letter I write is, this is a bill of attainder, bills of pains and penalty. How is it in the court of record that I am paying before being heard? I need to be heard. I face my accuser. So those, I still have not got an answer yet. But with the civil side, they just ignore it. They forget about it. But the thing is, I don't let it go. See, with attorney against attorney, they acknowledge what they're doing. They're not going to do this. They're not going to write court of record. They're not going to challenge jurisdiction. So it's like they're having a meeting of the mind. But when I'm there, I'm a man, I'm not going to let it go. This could go on and on and on. So they don't answer the court of record, because if they do, it's done. It's over.
Do you still show up for your dates, though?
Oh, yeah.
If they haven't
Yeah.
So what do? Do you stand there when you first get there and just keep saying, is this a court of record? Is this a court of... I mean, what do you do?
Everything is in my writing. So when they call your name, so they call me, I go, I am Rafi. I'm here on special appearance. I'm invoking all my God-given rights secured by the Constitution, and I'm here to rebut all presumptions. I have this thing. I say that, so that we get that out of the way. Because in court, if you do not say you have rights, they're going to assume you don't have it. It's that wicked. So I have everything in my writing. So when I go there, if the judge asks me any questions, I object. And if it doesn't go according to what I'm saying, I just keep on, filing motions to set aside, vacate, void judgment.
Yeah, but what would happen if the so-called judge just sat there and ignored everything you did and then doled out some penalty? You see where I'm going here? What if they just acted like you're speaking Martian? How do you deal with that?
That's what's going to happen. On the civil side, again,
there he goes around the block again.
I'm still in it, so it hasn't ended. They ignore all that. So what I'm doing is I'm getting a great paper trail for when I go to federal court. Because I know I'm going to get railroaded here. I know this state court, that building, I'm not going to win. Well, who knows? But I know I'm going to get railroaded. So what I'm doing is I'm setting it up for the federal district court when I sue the judge.
All right.
He has no judicial immunity.
So let's echo back to Alphonse and others who have said exactly what Rafi's just informed you, that at the municipal or even at the state level courts, it's likely you're going to be railroaded if you simply try to establish a common law jurisdiction. They're just going to trample over it, ignore it, act like it's basically Martian. So what's being said here is it doesn't matter because there's a record of all this going on. And the truth is that, and correct me if I get any of this wrong, once you get up to a federal jurisdiction, then any supposed immunity for the people who railroaded you is out the window, right? There could be penalties.
Yeah, when I go to federal district court, the way I'm going to bring an action against them is I'm not going to sue for money, because that way they could use qualified immunity. I'm going to get that out of the way. I want to spank them, sort of say, I want to correct this so they don't keep on doing this. I think that's kind of why I'm going this way. I'm doing this. Yeah.
Wait a minute. For the benefit of everyone, is that what you're saying?
Yeah. Sorry to cut you off. If I sue for money, they're going to go, okay, they could use qualified immunity. They could go, hey, this guy's in for money or whatever, and they could pay me off. So I'm not going to do that. I think it's time to get some judges off their seats.
This came up a number of law shows we did where I was basically pointing out we really don't have any way to know how many people have successfully established a jurisdiction and had serious matters dismissed just by knowing your rights, because so often when they settle with you, there's going to be a thing like, sure, we'll settle with you, but we'll seal this. You can't talk about this. So no one can know that you were correct. So I totally am into the noble way you're going at this. where you're looking to prevent them from doing it to your neighbors, to your friends, to your family in the future. And if everyone acted in this way, I'm guessing this railroading wouldn't go on for too long.
We need that. We need more people to study, you know, and get to know this and realize how far we've come. It's a wicked system. And let's fight, man, you know? So it'll be easier for everybody, for the next guy. And then hopefully they'll change, but who knows? Who knows?
So are you suggesting that at the lower courts, municipal or state, you've gone in, you've established that you're only showing up in a court of record, you're exercising your rights, you get, let's just say for the sake of conversation, you get railroaded, and they act like they don't even understand what you're saying, and they just keep proceeding. So what you're doing is getting a record. When you get up to the federal level, which Alphonse and others have pointed out, now you're in a court where something's going to get done. Are you suggesting the judges at the lower municipalities could actually lose their job as a judge for having done what they did there?
Yeah, it's what you put on the paper, what you want it for. At the bottom, you could put, I want a few $1 million, or you go, hey, you'll write something out, a nice paragraph, hey, this judge completely violated my rights, due process, and in my liberties, and infringe on my rights. This can't be happening, you know. And you could write a stipulation. I want him off the bench. I want him fired.
So in a sane world, basically what we're talking about here is regularly people have their rights violated, specifically due process, right? That's what we're talking about. And they do it by manipulating the so-called jurisdiction. In other words, let me ask you this question. If you walked into a municipal situation and you actually established that you're only interested in a common law court, you filed your papers, and let's say they recognize that, okay? Let's say everything goes your way. So you walk in, you verify it, hey man, am I in a court of record? Is this common? Yes. Doesn't that mean that there can be no attorney in that room against you?
That is true. It has to be a first-hand witness. I'm a first-hand witness. It happened to me. Where's the injured party? It's you deal man to man. It's man to man is basically what it is.
Just
you knock the attorneys out.
And to be fair, a woman
in court, likes must sue likes. A corporation can't sue a real man or a woman. Thus, a real man or woman can't really sue a corporation, not in these courts. Anyhow, the point is one guy in town cannot do anything. I've tried to teach law. If anybody out there wants to learn this stuff, dude, it is not hard. People are putting this stuff together, refining. I was hearing this stuff from my older sister's boyfriend in the 70s. So, hey guys, this stuff is not hard to learn. Take care. We got to go see what these cops are doing over here. So we'll check back in with some more of this.